Wendy, if you could put a sort of...
Okay. First of all, it is hard for us to begin to explain our story in the short time that we have today. But what we are here to tell you is about our experience at the hands of the family court system. A system which needs to be carefully scrutinised, overhauled and also opened up in order for people to get a fair hearing and for correct and just proceedings to take place. A system which is made up of officials and officialdom who very often do not act appropriately, as no one is there to check on what is taking place, leaving vulnerable families at the mercy of unscrupulous individuals. Although our experience may be considered relatively minor compared with other cases you will hear or may have heard of, the same close proceedings took place. This authority's lack of cooperation, not wanting to engage with we, the parents, despite having full parental responsibility of our 16-year-old adopted child, who is now being voluntarily accommodated under Section 20 of the Children Act 1989. Our child is not in care, came to the fore with this unnecessary court case. All that was required was for the local authority to get our consent for our child to leave the country on a holiday. This the local authority did not attempt to do. What they decided to do was take out a prohibited steps order to stop us interfering with the child going abroad, despite the fact that we had objected to this already and had good grounds for doing so. Least of all, we are the child's parents. We had encountered previous difficulties with the child abroad, and legally we are still responsible for our child. This was not the first time the local authority had taken actions with our child that required parental consent and did not obtain it. Our case in court was totally unnecessary, but demonstrated the lengths to which social services will go to cover up their own inefficiencies and to blame others. The social worker's statement supplied and evidence submitted contained factual errors and opinions being stated as fact, most of which had nothing at all to do with the case. For example, that I had said to a health worker that I had an alien monster inside me, and that someone in a meeting had said, "Has Wendy got Asperger's syndrome?" Also that another official had said that I had a personality disorder, and that was what was causing my adopted children's problems. When in fact this is a ludicrous statement to make, as our children did not come to us as babies, but were almost secondary school age, and couldn't read, tell the time, and didn't even know when Christmas Day was, to name but some things we had to contend with. Also their previous foster placement broke down. We have also found interesting phenomenon that very often it is the mother figure of the house who becomes the target of local authority misrepresentation and reports of factual inaccuracy. Stock phrases are used like emotionally abusive, physically abusive, non-cooperation, neglect, or cannot meet the children's needs at the time. On arrival at court we found the social worker and her barrister were already at court with a person who it turned out was the judge in a side room. We could see them. When we were called in, we asked if another adopter who came with us could attend, but were refused. But other people from social services just appeared in court. So there was two of us, lambs to the slaughter, and four of them. The judge did not want to see any of our evidence, and we were of the opinion that he already formed a pen picture of us as parents, given the defamatory and we believe libellous written exhibit which has been presented to him beforehand, as he had obviously read it and assumed we were unfit parents. That is what social services want judges to believe in courts, that parents presented before them are abusers of children, without any evidence in most cases or any redress for the parents. So are all then effectively stitched up by a legal system which does the weaving of the stitches. When we requested that the social worker read out her statement, her barrister refused to let her do this, presumably when he saw the 3 boxfuls of evidence we had brought with us. Incidentally, we represented ourselves and we knew nothing about the court system, as we have never been in any kind of trouble in our lives. We proved that the evidence produced was incorrect, but as expected the prohibited steps order and a specific issue order were granted, all because the social worker concerned could not follow procedures. We can easily see where this system can be used incorrectly, and with parents who are already suffering from the stress of dealing with social services and losing children, the whole thing has become unjust. There is obviously, as in our case, a cosy working relationship between the judiciary and social services. We do not want to appear to listen to the parents. Our main concern is that there is no organisation which actually checks that social services and social workers are following the law and procedural guidance. In our particular case, we have found approximately 6 regulations, 2 sections of the Children Act and 250 sections of guidance that have not been implemented and or followed by the local authority dealing with us. Our other concern is that individual cases like our own need looking at, as we may be able to take legal action if someone could look at what has been going on in our case, and indeed others that we know of. Our case for maladministration has been with the local government ombudsman for over a year. It has come to our attention that this organisation often comes down on the side of local authorities and buries their findings under something called a local settlement, which is where they offer you a small amount of money for your trouble and then expect you to go away into the ether. We are not interested in money, we want justice for ourselves and other parents and carers. Then to cap it all, the Ombudsman does not have to report what they have found out about the local authority for audit purposes. Once again, local authority wrongdoings have been hidden behind a smokescreen in order to keep their star ratings. When is someone going to stand up for the Leviathan called social services? The family court is the only court in the land where local authorities can say anything about an individual and needs no evidence to prove it. It is the only court in the land which does not allow an individual to stand up for their rights and to speak for themselves. If the family court is considered to be part of the British judicial system, where is the justice in that? Thank you.
Where are you actually from?
We live in Leicestershire.
Leicestershire.
Yes, thank you. Sorry.